Like this, based on one or two, as I declare you so, like this, I'm not the tribunal matter, INEC and APC don't finally drop that their finally written address when made they object since all of a sudden they do a hereby oppose, Like they are told them now, so they don't drop now. Yes, now. Each of them, like the two updates now bring us to this, so both INEC and APC, the final address they bring, each of them now 40 pages. Making a total of 80 pages. That's if I call they give now 80 pages for yes, so maybe person don't go crazy because of a tribunal matter. So like this instance, so now summary I just bring based on one of our sister misspells. Now you combine the summary. Come now, that's me. My your $10 summary. Make all of now here. When I'm gonna note the sub for inside the tribunal lifestyle. Without much ado, the way young people they talk, I might just go straight into the matter. So just listen to the summary of both INEC and APC, the way everything takes sub, what they take right time. Just the year so. That means bay. That say INEC introduced their final written address by mentioning that the petition of Labour Party and Peter Obi challenges Tinubu's declaration as the winner of the presidential elections conducted on February 25, 2023. They mentioned that their written address will demonstrate how the petitioners, which is Labour Party and Peter Obi, failed to show how they scored majority of the lawful votes cast at the election. They further stated that the petition filed by Peter Obi and Labour Party lacked merit and should be dismissed. In their brief summary of facts, they mentioned that as regards the issue of qualification, they tendered a letter dated July 6, 2022, which enunciated a voluntary withdrawal of Shetima as a senatorial candidate, and that this letter was tendered as Exhibit RA2. Now the year, they further mentioned that the alleged order of forfeiture by the U.S. District Court, which was raised as an issue to disqualify Tinubu, was never brought to its attention. On argument of corrupt practices and non-compliance with the act, they mentioned that the Labour Party and Peter Obi argued that they were mandated to use technological devices. Hence, they used the beavers for accreditation, verification, confirmation, and authentication of voters, and that the presiding officers were mandatorily required to transmit or transfer the result of the polling units directly to the collation system of INEC. In their defense, they mentioned that the collation of the election results remained a manual process, and that failure to upload the presidential elections with the beavers was a technical glitch. They say they talk this their glitch matter. No wahala. They further mentioned that the obligation to electronically transmit or electronically collate results of the election had been judicially determined by the Federal High Court, which leaves electronic collation and transmission to be discretionary. As regards non-compliance, they argued that all the arguments of the Labour Party and Peter Obi were false and unfounded. After a brief summary of facts, they addressed the evidence of the parties under different subheadings, starting with the Labour Party and Peter Obi's evidence on non-qualification. They mentioned that the Labour Party and Peter Obi led evidence through PW1, PW3, and PW12. Under cross-examination, PW1 struggled to deny that his evidence was simply his legal opinion and that he had not been an author of any authoritative book on constitutional or electoral matter. He also admitted that the U.S. District Court order of the judge that allegedly granted the forfeiture order was not registered in Nigeria. On Labour Party and Peter Obi's evidence on non-compliance, PW2, a software engineer, gave no details as regards his qualification, but pretended to give evidence in his alleged area of expertise. Yet, having no legal training whatsoever, also gave legal opinion on the Electoral Act 2022. Under cross-examination, he admitted to not being familiar with the beavers and that he could not state all the softwares used by INEC in the conduct of the election. PW3 on non-compliance tendered a video recording marked as PBH3 and PBH4. The video showed INEC's chairman giving assurances of the transmission of results electronically in real time. Under cross-examination, PW3 admitted that the chairman of INEC is still alive. PW4, a professor of mathematics, also testified and claimed that he uncovered 10,000 polling unit results out of an alleged 18,099 blurred results allegedly uploaded on IREV. Can't be allegedly, did there be no DD? Can't be all these people safe. He later admitted that there was no overvoting in the result. He also claimed that his evidence was precise and based on exact data, and admitted that the blurred result would not change the content of the original physical result. PW5, who is the director of operations at the Arise TV, appeared via subpoena as well to tender a video where the chairman of INEC stated that political parties should make comparison between results uploaded and the hard copies. Voila. PW7, who was a staff of Amazon Web Services as well as a member of the Labour Party, contested for the election into the House of Representatives. She testifies as regards the health of the AWS, but admitted that she did not have any access to INEC software infrastructure or cloud trail. She also admitted that she was not appearing in court on the mandate or authority of AWS. They also mentioned notably that the statement on oath of PW12 was deposed to on the 20th of March 2023, whereas the report of PW4, which he purportedly alluded to as the basis of most of his conclusions, were incomplete as at when he made his witness statement on oath. In addressing the summary of their own evidence, they mentioned that they called just one witness to tender exhibit RA1 to PA6. The witness mentioned that there was no electronic collation system. He further explained that it is a technical glitch on election day that prevented the smooth transmission of the polling unit results to IREF portal. All these people. He explained how this was resolved and tendered the Amazon Cloud Trail of INEC. He stated under cross-examination that he was one of those who designed the e-transmission system of INEC and that IREV was not for collation of results. In summarizing Tinubu Shetima's evidence, they mentioned that several documents marked as exhibit RA8 to RA27 were tendered, and only one witness, who happened to be a lawmaker, was called to testify. INEC raised 5 issues for determination. Now, one enter INEC now. Not the year. The first issue bordered on the qualification of Tinubu Shetima to testify. They argued that relying on the Supreme Court judgment in PDP versus INEC, Shetima was no longer a candidate for the senatorial seat, as at the time he was nominated as the vice presidential candidate, and that the tribunal is bound to follow the decision of the Supreme Court based on the principle of stare decisis under their law term. On the alleged allegation of fine imposed by the U.S. District Court, INEC simply said it was not brought to their attention, but still mentioned that the Constitution was particular about sentence in Section 137, subsection 1D. The second and third issues were argued together as they both talked about non-compliance. They argued that Labour Party and Peter Obi failed to prove this ground, stating that there is really no obligation on INEC to electronically transmit and collate results of the election or to suspend collation till results are fully uploaded on IREV. They also referred to Exhibit X1, which is the certified true copies of court judgment in the case of Labour Party versus INEC, which portrays that the point that INEC is at liberty to prescribe the manner in which election results should be transmitted. They also refer to PW4 Exhibit PCD1, which is the IRF's cause investigation document, which shows some data purportedly from results uploaded on the IRF. In the scores he put on those tables, Tinubu scored more votes than Peter Obi, and there was no table showing where Peter Obi had more votes or depicting how Peter Obi could have won the election. On the fourth issue, which dealt with the majority of lawful vote cast, INEC contended that no evidence was laid in this regard, which in effect means that the ground had been abandoned by Peter Obi and Labour Party. They mentioned that PW12 stated clearly that all votes recorded by INEC as cause of the political parties in the election were allocations and should be voided, included those of Atiku Abubakar. They further relied on the legal principle that states that any claim or defense pleaded which is not canvassed during the trial is deemed to have been abandoned. On the fifth issue, in relation to 25% in the FCT, they argued that Labour Party and Peter Obi only had 1/4 of the vote cast in 16 states, which is less than the constitutional required numbers of states. They refer to section 134, subsection 3B, which says 2/3 of all the states of the federation is needed to win. They further relied on section 299 to state that the FCT is just like one of the other states of the federation and does not enjoy any special status. They concluded by stating that the Labour Party and Peter Obi did not make any case for themselves. So, like this, so now the summary or the final address where INEC and the APC dropped today for based on the tribunal matter. No first say the video not too clear for you. That now this one I did the videos now. I just want to deliver and make people for know what the sub for the tribunal lifestyle. So after this one, so with the expect now next one for Peter Obi and Labour Party lawyers to file their own final address, which will supposed to come up in like 5 days from now. Now the update be this based on the tribunal matter like this today. So anyway they watch them from, I beg not forget to also share the video, make other people get interest for this tribunal lifestyle. Make them for see them, make them know within the sub for the country. Now this video, this summary come courtesy of one of our sisters, Miss Pears. That should bring this summary for us. So anyway, just thank God for everything.